This Amendment Act clearly militates against the guarantee of equality under Article 14. It treats equal persons unequally, and it creates a regime of citizenship that is predicated along religious lines, which violates the inherent idea of secularism that is a part of the basic structure of India's constitution. Now, the general and broad regime of citizenship in India is governed by Articles 5 to 11 of the Constitution. Article 11 explicitly accords to Parliament the power to make laws to regulate citizenship. It was this power that Parliament used when it enacted the Citizenship Act of 1955. Under this Act, it provided 5 different paths to citizenship: citizenship by birth, by descent, by naturalization, by registration, and through the acquisition of territories. And the law also defined an illegal migrant, and it prohibited illegal migrants from in any manner acquiring citizenship under those 5 recognized paths. It defined an illegal migrant as any person who has entered the territory of India without a valid passport or valid travel document such as visa, or who has entered the territory of India with a valid passport and valid travel documents, but where such documents have either expired or been rescinded for some reason or the other. Now, the present Citizenship Amendment Act seeks to amend this definition of an illegal migrant and exclude from its ambit certain categories of persons. Who are these persons? These persons are people who have entered India on or before the 31st of December 2014 and who belong originally either to Afghanistan, Bangladesh, or Pakistan, and who are either Hindu, Buddhist, Sikh, Jain, or Christian. Notably, therefore, the Act excludes a number of other neighboring countries such as Sri Lanka, Myanmar, and Nepal, for example. It also excludes Muslims from Pakistan, Bangladesh, and Afghanistan from the ambit of protection that it now offers. Now, these people who are then removed from the definition of illegal migrants are provided an accelerated path to citizenship, where the existing naturalization requirement of 11 years is reduced to 5 years. Now, why is this law bad? This law is bad and violates Article 14 of the Constitution because it effectively treats people situated equally unequally. To understand this, we need to look at Article 14. Article 14 provides that the state shall not deny to any person equal treatment or equal protection of the laws within the territory of India. Therefore, it places a specific obligation on the state to treat all people, regardless of whether they are citizens or non-citizens, equally. This therefore means that any citizenship law that is predicated along religious lines would be ex facie arbitrary and unreasonable. Now, no doubt, Article 14, while forbidding class legislation, does permit the state to make certain kinds of classifications. Why does it do so? It does so because not everybody is situated equally. Therefore, to achieve the substantive aim of equality, government will sometimes have to distinguish between people and will have to provide special benefits to certain categories of people. To decide where the government can do so, the Supreme Court has developed a test of reasonable classification. This test requires 3 things. It first requires a legitimate state aim. Second, it requires that the classification made is based on an intelligible differentia. And third, that the differentia drawn has a rational nexus with the object that the law seeks to achieve. Why, however, does the Citizenship Amendment Act violate Article 14? It violates Article 14 because it is neither predicated on a legitimate state aim nor does it make a reasonable classification. Now, if let's assume the object is to protect only migrants from certain countries, then the objective of the law will itself cease to be valid and will be arbitrary and fanciful. But let's assume that the object is to protect persecuted individuals from neighboring countries. Then the question is, why does the classification made exclude people from certain countries such as Sri Lanka, Myanmar, Tibet, and Nepal? Why not include these countries too? Now, let's assume that the objective is different. Let's assume that the objective is to protect people who are persecuted from pre-partition India. The question then is, why include Afghanistan? And why not include Myanmar? After all, Burma was part of British India up until at least the mid-1930s. Now, let's assume then that the intention is to only protect persecuted individuals from countries that have a state religion. Then the question then again begs asking, why not include Sri Lanka, which is a majority Buddhist state? Therefore, under any count, this classification is unreasonable and arbitrary. Now, the classification is also wrong in excluding Muslims from these three countries because, as we all know, there are many Muslims who are persecuted in Pakistan and Afghanistan as well. To take one example, the Ahmadiyyas from Pakistan have faced deep religious persecution in Pakistan. The first seems to be that individual Muslims can still apply under the existing regime of the Citizenship Act and therefore that their rights have not been violated in any way. Now, this is palpably wrong. The fact is that the Citizenship Amendment Act defines an illegal migrant and prohibits illegal migrant from acquiring citizenship under any one of those 5 modes that it prescribes. An Ahmadiyya from Pakistan, for example, would be considered as an illegal migrant after this amending act, whereas a Jain or a Hindu who is from Pakistan, Afghanistan or Bangladesh would not be considered as an illegal migrant. Therefore, it's quite obvious that the amending act seeks to place equals in an unequal position. The second argument is that there's been a dwindling of the minority population in these 3 countries, in Pakistan, Afghanistan and Bangladesh, and therefore that these communities deserve special protection. Now, this argument is once again wrong for 2 or 3 reasons. The first is that there's been a dwindling of Sri Lankan Tamils as well in Sri Lanka, and there's well been a dwindling of Muslims in Myanmar as well. Now, the second argument here is that it cannot be a ground that a community constitutes a minuscule minority and therefore does not deserve the protection of fundamental rights. The Supreme Court has repeatedly held that however small a community is, such a community is equally deserving of the protection of fundamental rights that the Constitution accords. And in the case of Article 14, it protects both citizens and non-citizens alike. The third argument that appears to have been made is that if this law is struck down, other laws that accord special benefits to minorities and makes reservations, for example, to scheduled castes and scheduled tribes would also have to be struck down. This argument is also fallacious on many levels. For one, as we saw earlier, a law that seeks to provide special benefits such as housing to low-income households can be valid so long as it makes a valid, reasonable classification. Now, in the case of reservations for scheduled castes and scheduled tribes and other backward classes, the Constitution itself provides for these, and in fact, the Supreme Court has held that these are not merely exceptions, but are inherent in Article 14 in the sense of achieving substantive equality. The idea remains that people who are placed unequally have to be treated unequally by according to them certain special benefits. The fourth argument appears to be that the trigger for the persecution in the case of these communities from Afghanistan, Bangladesh and Pakistan is different from the trigger of persecution, for example, of the Ahmadiyyas from Pakistan. As we've seen in India as well, the fact that a trigger for persecution is different can scarcely be a ground for a differential treatment. Now, whether a persecution is based along sectarian lines or along religious lines, the fact remains that persecution is a matter of fact. It also remains that Ahmadiyyas from Pakistan are in fact persecuted on religious lines and not on sectarian lines because their persecution stems from the faith that they hold as opposed to the fact that they constitute a different sect. The fifth argument is that Article 11 of the Constitution grants to Parliament the power to regulate citizenship, and therefore such a parliamentary law is somehow beyond judicial scrutiny. Now, this argument is simply fallacious. Any law, regardless of what kind of law it might be, is a law that is subject to the rigors of fundamental rights. Now, nobody here is questioning the competence of Parliament to enact a law regulating citizenship. All that we are saying is that this law violates fundamental rights, in particular Article 14 of the Constitution. Now, to understand this, we only need to look at Article 13. Article 13 defines what a law is and includes within its ambit legislations made by Parliament. So, any parliamentary law that makes or regulates citizenship has to subscribe and has to be amenable to the power of judicial review and must be compliant with the guarantee of the various different fundamental rights contained in Part 3 of the Constitution.